Good day, my beloved brethren, all the authorities of West Region 7, Redeemed Christian Bible College, Oshogbo, and our beloved matriculants. I want to congratulate you on taking this decision to enroll in the Redeemed Christian Bible College. You are welcome, and I pray the Lord will see you through successfully in the mighty name of Jesus Christ. I am required to take you Introduction to Legal Studies, GES 213. Introduction to Legal Studies. We will proceed with some definitions, and then I intend to take you through as much as I can within this time limit allotted to me. We have classification of law, sources of Nigerian law, hierarchy of courts in Nigeria, law of contract, law of torts. We will take some specific torts like assault, battery, nuisance, trespass to chattel, conversion. Then we go to contract, part performance, mistake, duress, undue influence. We may be able to take some of those, including mortgages. But more importantly, we must be able to take wills and codicils, who is a next of kin, and the all-important topic of fundamental human rights. I will breeze through most of these, trusting God that you will be able to also read up and fill up from some other sources. So I will take as much as we can within this time. Let's start right on. Law is a subject or a topic that covers all aspects of human existence. So there's no universally accepted definition of law. Somebody said, law is like some blind men standing around a big elephant. One is holding the tusk, which is smooth and hard. One is holding on to the leg, which is big, coarse, and very sturdy. One is standing by the trunk, which is just like a massive wall. One is holding the tail. So if all these blind men are asked to define what is an elephant, they will only define it according to the side where they are standing. And that is exactly what law is. Most definitions of law are colored by the focus or the bias of the definer. So you may view law in terms of the authority that prescribe it. For example, people will say there's federal law, there's state law, there's local government law, mosaic law, ecclesiastical law, and so on and so forth. But by and large, I think we can say law is that body of principles and regulations that are prescribed. Take note of that. It must be prescribed or emanating from a government. There must be authority behind it and applicable to a people, whether in the form of legislation, customs, practices, policies that are recognized and enforceable. That's another key word. It must be enforceable. If it is not enforceable, then it's not a law. You have some definitions by Professor T.O. Elias, a legal titan, who says a law is a body of rules which are recognized as binding on its members. So he didn't talk about the source. His own is that it is a body of rules. Once it is recognized, wherever it came from, if we all agree for it to be binding on us, then that is our own law. Another scholar, Sonny A.O., defines law as a body of rules designed, formulated to guide human conduct or actions, which are enforced among members of a given society or state. So you can have a lot, your own definition. So it's up to you now. You have been introduced to it. You can come up with your own definition of what law is. So the most important thing is do not be caught on the wrong side of the law. And that is why we are having this lecture. The church, we all know the church, organization of Christian believers generally, or in any of the various branches or denominations. We study in this course some elementary but fundamental aspects of law that affect the daily activities of a man of God or even of a Christian, either at family level, social level, ministry level, or even your job level. Why do I need to study law as a minister of God? The Bible, even the scripture says, Proverbs 28 verse 7, he who keeps the law of God and man is a wise and discerning son. That's the Amplified Bible. It says, he who keeps the law of God and man is a wise and discerning son, but he who is a companion of gluttons humiliates his father and himself. And 1 Timothy chapter 1 verse 8 says, we know that the law is good if we use it lawfully. The law is good if we use it lawfully. And that brings out a point. It is the use to which you put law that determines the color that law is. The side of the Lord where you are standing that determines what law is to you. You've heard people say that law is an ass. An ass can carry, I believe an ass should be a donkey. As a donkey can carry your load, help you. And if you stand in the wrong side of the ass, it can also give you a kick that can kick the living daylights out of you. So the counsel is make sure you are on the right side of the law. Importance of law. So a basic knowledge of law is very important, essential, so that the minister of God will be able to satisfactorily discharge his duties without hiccups and to teach others to be law-abiding. Because no matter the anointing that is jumping out of your head, even if fire is jumping out of your head, and you fall foul of the law, and they have to put you behind counter on a Sunday morning, you have already destabilized the service or church on that day. Or if you do not handle your tenancy properly, or the property, the law of property, maybe you did not acquire the church property in a lawful manner, you may find yourself on the wrong side of the law. Incidentally, recently we were considering doing some construction across a stream that was giving us trouble. One of the places we went to look at was a place where they used some very strong iron to construct a bridge across the stream. But when I saw the iron that was used, I saw that this is an iron from a rail track. And I immediately told the engineer and the people that went with me that, please, this is rail track, this is federal government property. If we use this to construct our bridge, any day, any time, any policeman can come around and ask us, where did you get this? As if I was prophesying. Just this week, I've started reading the Minister of Transport giving order to all policemen that anywhere they see anybody vandalizing rail equipment, they should be arrested. And just this morning, I read that one special assistant in one of the states, I think Nasarawa State, was arrested for being in possession of rail tracks and is in a big trouble now. So it won't do for a minister of God to be caught in such things. The essential aim of law is justice. And in achieving justice, we seek to do several things. Number one, protect victims and punish the offender. Number two, regulate human behavior and good relations between authorities and persons who are with different diverse interests. Number three, we create and regulate arms of government that set out their duties and responsibilities. Number four, to resolve disputes that will arise. Disputes will always arise. There's no way that we will not have disputes. And one of the leading causes of dispute is limited resources and allocation of those resources. For example, today, open grazing, Fulani herdsmen, conflict between herdsmen and farmers is basically as a result of limited resources. When we were growing up, Fulanis, we come across Fulanis just once in a while. But you hardly can spend a whole day today without coming across them in one corner. They are all over the place. The resources, we used to see them inside bush, deep bush. Today, they are not only in the bush, they are inside the towns because population has increased. An example of what can arise when there is scarcity is what you find in 1 Kings. In the case of one woman, these two women that overlaid their baby. 1 Kings chapter 3, 16 to 28. 1 Kings chapter 3, 16 to 28. Verse 28 specifically said, when all the people of Israel heard about the judgment which the king had made, they were in awe and reverently feared the king, for they saw that the wisdom of God was with him to administer justice. The aim of the law is to do justice. Let's go to classification of law. Module 2. Law probably started with, classification of law probably started with the Romans, who had separate set of laws for Roman citizens and another for foreigners. You remember when they flogged Paul the Apostle, he started quoting law. He's a lawyer. So, is it lawful for you to flog a Roman citizen? And you discover that immediately the centurion, the soldier, the officer that conducted the flogging was afraid when he heard that Saul was a Roman citizen. So they had different law for foreigners and for citizens. So other classification, you may have private law, civil law, which regulates relationship between individuals entering into contractual relationship. You may have public law, which has to do with relationship between government and its citizens and between two government agencies. Municipal law is that one that is existing within a territory. That's like local law. International law can be public international law or private international law. Public international law regulates the rights between states, between two countries. Private international law regulates the relationship between citizens of different countries. One in UK, another one in Nigeria. They do business together, and you want to know which law will guide them. Criminal law deals with acts of omissions that are punishable by the state. As a general rule, an act of omission is not a crime unless it is defined in a written law and the punishment is prescribed. Under criminal law, you have felonies, misdemeanors, and simple offenses. You have civil law. You have civil procedure law or adjectival law. That's the one that lawyers use to prolong matters. You can be on a procedural issue for several months, and yet you have not yet determined whether Mr. A is actually the one that stole the goat or not. You can use about 2 or 3 months arguing whether the judge has jurisdiction and things like that. Things like that are procedural law. You have common law, which is developed by the old common law courts of England, largely contained in customs and judicial pronouncements. This can cover both criminal and civil law. You have equity. The law of equity is very interesting because it's largely, you can say it largely originated from the ecclesiastical circles. The Lord Chancellor in England was vested with seeing to the justice of the rigor, to mitigate rigors of that people were going through, citizens were going through at the hand of the common law. The common law says, an eye for an eye, a tooth for a tooth. You must exact your pound of flesh. If you say you are going to do this, you must do it, whether the heavens fall or whether there is an earthquake. But under equity, the Lord Chancellor was given power to intervene in discerning cases. In doing this, the Lord Chancellor did not follow any established principles in dealing with cases. He was guided by conscience. What is conscionable in this case? What will achieve justice in this case? When there is conflict between the rules of equity and that of common law, the rules of equity will prevail. We have customary law, which consists of customs and traditions that are accepted as binding on members of a community in regulating their relationships and peculiar to their social, economic, political, religious, and cultural background. It may be written, it may be unwritten. It may be unwritten and subject to change or adaptation. Now, the introduction of English common law in Nigeria brought in what we know as the repugnancy doctrine, in such that even our customary law now began to be tested in the light of foreign considerations. Because when the British came, they introduced the repugnancy doctrine, which basically abolished customary laws and traditions, which are considered to be barbaric. The question is, barbaric according to whose judgment? According to the Englishman's judgment. So, under the repugnancy doctrine, a customary law to be valid must not be repugnant to natural justice, equity, and good conscience. It must not be contrary to public policy. It must not be incompatible directly or by implication with any law for the time being in force. For example, in the case of Edet and Essien, the bride price on Inyang was paid since she was a little child. Years later, Edet obtained consent of Inyang's parents to marry her and also paid her bride price. Edet and Inyang had 2 children. Edet was laying claim to the 2 children of Essien was laying claim to the 2 children of Edet and Inyang on the ground that he was the one that he was still married to the Inyang when she contracted the illegal marriage by custom, and so therefore the children belonged to him, since he paid the bride price, which has not been refunded. So the court held that customary law was repugnant. The mere payment of bride price, and you are not the biological father of the children. You want to claim another person's children just because you paid bride price on the mother, who eventually did not get married to you. Sources of Nigerian law. In Nigeria, you have basically about 5 sources of law. Number 1, we're in Module 3 now, Nigerian legislation. And for this, you have English law, which is consisting of common law, doctrines of equity, and statutes, and then some subsidiary legislation. For this category of law to be effective in Nigeria, we have a cutoff date, and that date is January 1, 1900. It must be in the category of laws that were in force in England on the 1st of January 1900. You have another source of Nigerian law, which is customary law, which we have already mentioned, which consists of ethnic customary law and Sharia law. Ethnic customary law of each of the tribes, and then Sharia law for the Muslims. Now, ethnic customary law is largely unwritten, but in Sharia, you see that they have codified the Sharia law. And I think the school of Sharia law that is operating is the Maliki school in Nigeria. Now you have judicial precedents as a source of Nigerian law. Here we have studies, you talk of technical terms, stare decisis. That is, you must follow the decision of earlier courts in order to make for law and order. You must follow the decision of earlier courts that are binding on you. Ratio decidendi is the reasoning behind any judgment. So you must distinguish, when you are reading a judgment, you must distinguish between mere opinion expressed by the judge and what we call obiter dicta. That is the ratio decidendi. That's the obiter dicta is mere opinion expressed by the judge. Ratio decidendi is the actual decision. If I say, I think the sky is blue today, it doesn't have anything to do with the decision. And I say, I hereby order that Mr. A should refund the sum of 500,000 to Mr. B. That is a decision. So we must distinguish between what the judge is just saying to express an opinion to illustrate a case and what he actually decided in treating judicial precedent. You have other secondary sources of law, the law reports, textbooks, periodicals, journals, opinions expressed by learned people and learned jurists, law digests, law dictionaries. So when there are cases to be determined in court, sometimes we bring up all these. These are the sources of Nigerian law. Now let's look at the hierarchy of courts in Nigeria. You have the Supreme Court, which is the highest court in the land, under Section 230, 1999 Constitution. You have the Court of Appeal, which is next in hierarchy. Any decision given by the Supreme Court can only be overruled by the Supreme Court itself. No matter how wrong it is, every court below the Supreme Court must follow that judgment. And even the Supreme Court will not lightly just overrule itself, just anyhow like that. I think recently we had a case like that. I think one of the governorship cases where some learned senior advocates went back to court after a judgment had been written. They went back to Supreme Court and said that the Supreme Court should overrule itself because they believed there was a mistake. They were lambasted for it. The court did not take it very, very kindly at all. You have the Federal High Court, Section 246 of the 1999 Constitution. The Federal High Court is different from the state high courts in some respects. The Federal High Court has exclusive jurisdiction in civil matters and cases stated in Section 251 of the Constitution as amended, and it has concurrent jurisdiction with the state high court in certain matters. For example, banking relations, interpretation or application of the Constitution, and enforcement of fundamental human rights, especially enforcement of fundamental human rights. The High Court of the Federal Capital Territory, you have the Federal High Court of the Federal Capital Territory and the State High Court. So you call all of them high courts, but the Federal High Court, in its decision, in its function, is somehow different from the State High Court and the High Court of the Federal Capital Territory. You have the National Industrial Court, Section 254A. You have the Sharia Court of Appeal, Section 260, which provides for the establishment of Sharia Court of Appeal for the FCT, while Section 275 of the Constitution provides for states that require it. Recently, just this morning, I read that the Southwest states want to start their own Sharia Court of Appeal. They want to establish Sharia courts in the Western states alongside the customary court that we already have. So that brings me to the next level, level of courts. That's the customary court of appeal. These are the Sharia Court of Appeal and customary court of appeal. Here, appeal from customary courts and Sharia courts. Then you have the magistrate courts and district courts. Magistrate courts and district courts, these are courts of inferior jurisdiction. They are not courts of record. Although they are provided for in the Constitution, they are established by the law of this particular state where they are set up. And magistrate courts are found, they are courts of summary jurisdiction, like I've said, and they are determined by the issues in the court are determined by the court without pleading, without briefs, having to file pleadings or briefs. You also have customary and area courts. Now, let's go to contract. The law of contract, that's Module 5. What's a contract? It's an agreement which the law will enforce or recognize as affecting the legal rights and duties of the parties that are involved. So, there must be mutuality of purpose and there must be intention. There must be mutuality of purpose, that is a meeting of the mind, what we call consensus ad idem. Are you agreed? Is your mind, we are talking about, are we sure we are talking about the same thing? And then there must be intention to create legal relations. There are different categories, classifications of contract. Basically, there are two. That's formal contracts and informal contracts. Formal contract and informal contract and formal contract and simple contract. Now, simple contracts are contracts that are other than formal contracts. And the simple contract may be in writing or oral. It is also called parole contracts. A formal contract is made by deed. It is also known as a contract under seal. Formal contract must be written or typed on paper or parchment. And it must be signed, sealed, and delivered by the party executing the contract to the other party. You have express contracts and implied contracts. Express contract is described as one that is expressed when the terms of the contract are clearly stated. There are, however, other categories that are implied, because the court will normally construe the existence of a contract from the conduct of the parties rather than from their words or correspondence. There are times that they say action speaks louder than words. So there are things that you have been going together, and you already assume that this is what is going to happen. You may not have had the opportunity of reducing it to writing or expressing it in any particular way. When such a conduct is found, the court will normally imply that there is a contract. Now, there are bilateral and unilateral contracts. Bilateral contract is exchange of promise between two people. The offeror, the one who makes the offer, is called the offeror. He promises to do something in exchange if the offeree, the one who is receiving the offer, also promised to do something else in return. That something for something is what we call consideration. Consideration. The consideration is the mutual promise. So if I promise to pay the sum of 300,000 if Mr. B will give me a Honda Toyota Camry car, the sum of 300,000 I promise is the consideration. And once the offer is accepted, it is binding. However, it raises another issue. Sometimes we look at consideration. We want to raise an issue whether the consideration is adequate. The law does not generally want to look at whether the consideration you are offering is adequate. So far as it is known, it is established that you actually intended to make this transaction. The law does not want to know whether it is adequate. The only area where the law will be looking at whether it is adequate or not is whether you actually had the intention of having a binding legal relations. So you have unilateral contract, which is somebody just decides to make a promise. An example, excuse me, example of unilateral contract in Nigeria, for example, is the sales promotions. that are usually done by manufacturers. If you do this, we will give you this. Anybody who meets that condition is entitled to go and claim from such people. In the case of Khalil and Kabolik Smoke Ball Company, the defendant company advertised in the newspaper that he will pay £100 to anyone who used their smoke ball and for at least 2 weeks and still succumbed to influenza. That's like catarrh or cold. Now, the plaintiff bought one smoke ball and used it according to specification, and he still caught influenza. And he brought an action against the company. The company said, no, they didn't intend to create legal resistance, and the court said, no, you made a unilateral contract. You made a promise, unilateral promise. And any member of the public is entitled to have accepted your offer. What are the elements of a valid contract? There must be offer. An offer must be precise. That is what you are promising to do. You are undertaking to do something or promising to do something. It must be precise. It must be unequivocal. It must not leave any room for speculation as to the real intent or content of the mind of the person that is making the offer. So once it is clear like that, then you say an intention to create legal relations is there. There's no limit to the number of offers which an offer can be made to. Now, if an offer is not clear but merely a preliminary move, sometimes people are just sending out feelers. They want to enter a contract but they have not made a specific offer yet. We call it invitation to treat. They are just going out and say, I am ready to do business in this respect if anybody is interested. That is not an offer. For example, an auctioneer who says this cup is going for 90 naira, going. He has not made an offer. He's only making an invitation, sending out invitation to treat. Make your offer. And that is why somebody can say, okay, I pay 100, I will pay 90, and somebody says, no, I will pay 95, and it begins to rise. It is when the auctioneer's hammer falls, bam, he says, going, gone, bam, and you say, okay, the cup is sold. Acceptance may be manifested by the conduct of the parties, by their words, by documents. It's an expression of assent to the terms of the offer. So, like I said, in an auction, for example, when the auctioneer says, this cup is going for 90 naira, and there are several people in the room. Somebody says, I will pay 95. It's not yet done until the man. It's an invitation to treat, which the people in the room will now be making their offers. And the offer is accepted when the auctioneer's hammer lands on the table. There may be counter offer, because an acceptance must be correspondent exactly to the terms of the offer. If I say, I will sell you a Toyota Camry car, this thing, 2008 edition, and you come back and say, I agree to pay you the money if the car is tinted, it has tinted glass, and it has leather seats. Now, you're already introducing some other elements. Now, we have to sit down and agree again. So, you have made a counter offer. And unless I agree to your counter offer, then there is no deal. Crossover. Sometimes the two offers meet, they jam each other on the road. How can an offer be terminated? It can be terminated when there's revocation. I say, no, I said I will sell you, but I'm not selling again. I revoke. Lapse of time, maybe the time given is too, maybe I promised to sell you a Toyota Camry 2004 edition in the year 2004. And then you are coming to me in the year 2020. Lapse of time. You didn't do anything for so long. Death of the offeror or offeree. When the offerer, the person that made the offer, dies, or the person that the offer is made to dies before a contract is consummated, it can be terminated by rejection. You also have revocation. So you have revocation, lapse of time, death of the offeree or offeror, and by rejection. Now, you can also, then we go to the issue of consideration. This may be rights, interest, profits, or benefit accruing to the party, or some forbearances, some detriment. It doesn't have to be money. It can be something that you forbear to do. But largely, a person that has furnished no consideration in a contract cannot bring an action. So the first thing they want to ask you is, what is the consideration that you have? Now let's go to the contract of employment. That is very important. Or contract of employment, that's a master-servant relationship. Now, there's no fundamental human right to employment. You cannot force an unwilling servant on an unwilling master, and vice versa. So you don't have a right to employment unless you have a contract of employment. So your employer is not entitled, is not obliged to keep you in employment for any period of time except according to the terms of your agreement. So if he says, go tomorrow, the court will look at the letter. If he gave you a letter, what is the length of notice he's supposed to give you? And by and large, an employer can always hire and fire, provided he follows the law. Now, categories of contracts of employment. You have ordinary contracts, contract of fixed for a fixed time, and then you have contracts that are protected by statute. University lecturers, for example, they are judges. Their terms they are protected by statute. Judges, you cannot just get up tomorrow. The governor says, "No, Judge, I sack you." You must follow. The law provides for how a judge can be removed from the office. Let's go to Module 6, tort, law of torts. Praise the Lord. Now, the law of tort, the aim of the law of tort is to compensate people that are harmed by wrongful conduct of others. In the law of torts, it's a civil wrong involving a breach of duty that is fixed by law. Now, such duty may be owed generally to the members, and it must be redressed primarily by an action for damage. So let's go into some aspects of thoughts. Now, intention, mental element of thoughts. If I stood up and I just want to stretch myself and unknowingly my elbow hits you, there is no intention to cause you bodily harm. But in considering this, you must also bring in the issue of negligence. So if I ought to know, if a reasonable person ought to know that somebody's nose is in that place, maybe I just get up and I start swinging my arms widely in a crowd when I know that people are around. The law will sometimes look at me and say, listen, as a reasonable person, you ought to know that your arm will connect with somebody's nose. Now, this person has a broken nose. You are negligent. So there's this thing, relationship between intention and negligence. When an act is intentional, if it is done with full awareness of the consequences, and you can say the person has a desire to produce them. Say, I'm going to deal with that man, and I go out and I give him a punch. That is intentional. But if I am swinging my arms, like I said, just irresponsibly, and the people are around, and there is a connection with somebody's nose. That is negligence already. Talking about negligence, you ought to know. The court will take, you ought to know. So there's a difference between negligence and intention. Intention indicates a desire for the consequences, but negligence is that you are careless as to the consequences. You have strict liability offenses where the law will say whether you intended to do it or not, you already did it, you are responsible. If I keep a wild dog and I don't restrain it, and the dog escapes and bites somebody, I will not say, well, I didn't set the dog on him. The dog just went on his own. The court may not be ready to look at my intention in that case. There's motive and malice. Also, consideration of motive and malice in dealing with torts. Now, you also have classification of torts. Torts, like we said, are civil wrongs. No, so you have torts that are relating to personal interests. Personal interest. And then in this category, you have trespass to the person, assault, battery, false imprisonment, negligence. Then you have property interests. The torts that deal with property interest. This is interference with the property right of somebody. You have trespass to chattel, conversion, detinue, nuisance, and negligence. I'm really interested in this area of nuisance because sometimes you have actions brought against our churches for nuisance, basically nuisance of noise. You have a tort that protects a person's interest in reputation, such as defamation of character, libel, and slander. You have torts against economic interest, deceit and passing off. If I'm producing shea butter cream and everybody already knows it because it's this, and I call it a particular name, Olajide shea butter, and because you see that it is selling very well, you also go and produce your own shea butter. But instead of calling it Johnson shea butter, you call it Olajide shea butter. You are passing off because you want to reap where you have not sown. You want to reap from my reputation that I have built over the years, which you have not sown into. Now, interference with judicial process. That's another category of tort, and that is the tort of malicious prosecution. If you initiate a process which leads to the prosecution of somebody wrongfully, then an action can be brought against you for malicious prosecution. And then there's torts that interfere with family relations. It's enticement and harboring. So let's go to the specifics now. We have assault and battery. I don't know whether I want to dwell too much on that because of time. Like I said, I want to go to nuisance. Yes, nuisance. I've already said some things on negligence. Now, nuisance, popularly you use it to inconvenience or annoyance. And the law of tort, it has to do with your action, which causes damage or inconvenience to the people that suffer it. Emission of noxious fumes from a factory, noise, obstruction of a public highway. You want to have a special program and you just arrange your chairs across a highway. Destruction of a building through vibrations and interference with easement of way. So these are categories of nuisance. Types of nuisance, you have public nuisance. That one is generally to everybody. Everybody is suffering from it. And you have private nuisance. The difference is that one affects the public generally, And for you to bring an action, if it's a public nuisance, you must show that you suffered specially over and above everybody else. Not as to degree now, but that there's a special way this thing affects me more than everybody else. Otherwise, the public nuisance must be redressed by the public authorities. But in private nuisance, you are entitled to bring an action to redress private nuisance. And you must show that there was physical injury to your property. When maybe your crops are damaged or destroyed by the fume coming from the factory, you have a substantial interference with your use and enjoyment of your land, and interference with easement and profits. Those are the elements of the offense of nuisance. Praise the Lord. Let's go to, I think I will jump trespass to chattel, or let me just do brief through it. The thought of trespass to chattel seeks to protect your interest in your property, your interest in the condition of the property, your interest in the property against interference. The act of trespass it may arise from destruction, damage, or mere use of the property or chattel wrongfully moving them from one place to another without the consent of the owner. Trespass to chattel is actionable without proof of actual damage. You don't have to show that something was damaged. It is enough. For example, when you go to a zoo and they say, don't touch an animal, and you touch, already you are that's actionable. So trespass is protecting possession, not ownership. It doesn't mean that you intend to deprive me of the owner. If it has intention to deprive me of the ownership, that's already talking about conversion. So the owner of a chattel will be liable in trespass if he interferes with it at the time when it is in the lawful possession of another person. So if I hire my car out to you and you have paid the cost of the hire, and I just came out and I saw the car driving across, that is my car, and I stop the driver, I take over the steering, I say, I have somewhere to go, after all it's my car, and I use it, I will be liable for the period I use that car because I have already collected money, hired the car out for that period. Conversion, on the other hand, is similar to trespass because they both protect possession rather than ownership, although they differ in some respects. Praise the Lord. You have different things, acts of conversion, and so on. I think at this point I need to jump to wills and codicils. Wills and codicils, if there's still time, we may come back to the other categories of tort and contract. Now, what is a will? A will can be defined as an instrument which a person makes the position of his real and personal property, and it takes effect after death. That's why we say a will speaks from death, and by its own nature it is revocable. Because it speaks from death, it means until the man dies, he can make as many wills as possible. He can wake up today and cancel the will we made yesterday, and tomorrow he wakes up and says, no, I don't want that will again. So as many wills as he can make, the latest one is what the court will, the latest one before the testator dies, is what the law will recognize. What are a will must be signed by the testator, must be properly signed by the testator. It must be written, signed by the testator or some other person in his presence by his direction. You can ask somebody to affix this thing on your behalf, it must be signed by the testator in the presence of 2 or more witnesses, and the 2 of them must be present at the same time. When making a will, it must be made voluntarily, not under duress or undue influence. You must possess sound mind. Otherwise, a will made by a person of unsound mind shall be void and of no effect. And however, under which law, a testator cannot dispose of property that is subject to customary law. If the property it belongs to your ancestral, this thing, according to native law and custom, you cannot go and alienate it. Dispose of it by will, or bequeath it by will, because what is ruling that land, that property, is customary law. Now, before I leave that, I say something about if a will is made under undue influence. I think we are supposed to have treated undue influence, duress and undue influence. Because we may not be able to go back to it, let us know the categories of people that may be held to have undue influence on people. As a pastor or a minister, a spiritual leader or advisor, you are in a position of authority over people. So when a man or a woman comes and he says, I am giving you my land as my pastor, be careful. Because the law will take it that you have this authority over her, you are in a position of authority over him or her, which makes the person to have some undue influence. So the law will look at it. It is not that it's expressly prohibited, but the law will look at it very, very strictly, especially if there is there's an objection from anywhere. So when you are getting anything from a member of your congregation, a gift, be careful. Make sure you take absolute precaution. Make sure that it is properly done, and in such a way that nobody can come around and say, no, we don't even know what they used to catch our daddy that he gave this thing. And we have seen so many cases like that, where the owner of the land will say, I gave this thing to church. After the man is gone, the children of the man or the woman will rise up and say, no, our daddy couldn't have been in his right mind to give all this land to church. No, it's not true. So the solution is, make sure you take all the legal, if it's a gift, make sure there's a deed of gift properly signed before witnesses, valid witnesses, so that there won't be any. Let's go to next of kin before I round up. We still have fundamental human rights. Next of kin, this is a general term that all of us are familiar with. And so what's the next of kin? It can be used to mean two things. Number one, the nearest blood relation, according to the law of consanguinity. Then it can mean those that are entitled to take under statutory distribution of your estate. So it's not necessarily confined to relatives by blood, but it may include the relationship existing by reason of marriage. And it may embrace persons who, in the natural sense of the word, bear no relationship to you by blood at all. So it may be used to refer to closest blood relatives of a person. It can be used to refer to persons that are entrusted with decision-making powers in terms of emergency. Who do we contact when there's an emergency? Then these people need not to be relatives of the person nominating them. Sorry, I did not mention in wills, a person of capacity. It can be made only by a person of capacity. To make a valid will, you must be 18 years old at least, unless you are a seaman or a military man serving in the army. The reason why these people are allowed, even if they are not 18 years old, or if they already find themselves inside in this category, the law allows them to make wills. The reason is not far-fetched, because these are people that hold their lives in their hand anytime. So Next of kin can also refer to persons that are entrusted with decision-making powers in terms of emergencies. They may be persons that are entitled to inherit the estate of a deceased person in the event of intestacy. Such person must be related this time around to the intestate by blood or marriage. However, when you are looking for to locate the next of kin, you normally go to the law and not to the person's choice or discretion. When it's talking about inheritance, the law may not necessarily stop by just expression of next of kin. For the purpose of succession, your next of kin is determined by your personal law. Your next of kin is determined by your personal law for the purpose of who will succeed to your property when you are gone. So the general rule is, however, altered by the incidence of marriage. And it is the nature of marriage that a deceased person has that will also determine whether it is customary law, English law, or that will apply, depending on the jurisdiction. There are technical areas which I don't need to bother you with, the administration of estate law, and so on and so forth. Now, there's a hierarchy, exhaustive hierarchy of the persons who are entitled, under some circumstances, maybe to inherit, and the hierarchy is roughly in this, largely in this manner. Number one, the surviving spouse, then followed by the issues of the marriage, then you have the parents of the intestate. These are general considerations. There are some intricacies which I don't need to bother you with now. So where a customary law is applicable, the next of kin of an intestate are those that are under the native law and custom that are entitled to inherit his estate. Under Nigerian law of intestate succession, you cannot choose your next of kin. The law will impose them. So, don't forget, I said there are different meanings of the word next of kin. All I've said so far is relating to the inheritance of property when a person is gone. It's different from next of kin of who do we contact when there's a problem, when there's an emergency. Then let's close with fundamental human rights. Fundamental human rights. These are rights which by their nature have become very basic and are important. They are taken as indispensable to human existence to give life the desired quality. Without them, life loses its quality. They are not just mere rights, but fundamental. And it is they are rights that stand above the ordinary law of the land. So if there is any law that is promulgated today and it runs contrary to these fundamental human rights, the law will be struck down, no matter the authority that made the law. These are rights that are applied to every citizen, irrespective of age, place of birth, race, religion, or gender. Now, fundamental human rights are generally a set of legal protections that, in the context of the legal system, they are still to be enforced under the law. Under the 1999 Constitution, you have them in Chapter 4 of the 1999 Constitution, and you have the right to life, the right to dignity of human persons, the right to personal liberty, and so where in right to personal liberty, it means nobody can hold you down except with the intervention of the appropriate authorities. In this instance, a court. So under the right to personal liberty, where cases where you can be deprived of your personal liberty the established procedure must be carefully followed. That's why you have judges giving bail, policemen taking somebody to court on holding charge and granting administrative bail. The procedure must be properly followed. And when the person is arrested, he must be informed in writing within 24 hours of the grant of his arrest. And when there's detention, if the person is detained eventually, in accordance with the constitutional provision, he must be brought before a court of law within a reasonable time. That is the area where policemen now hide. There is a reasonable time. They say, well, we are still conducting investigation. So we have the right to fair hearing, right to liberty, personal liberty, right to fair hearing. And under the right to fair hearing, you have the twin principles of thou shalt not be a judge in your own cause. That is nemo judes in causa sua. You must not be a judge, cannot be a judge in your own cause. The reason is not far-fetched because there will be bias. In Yoruba they say there's nobody they give hoe to hold the ground that will not hold towards himself. Then number 2 is the second of the twin is audi alteram partem. Audi alteram partem. You must hear both sides. You must hear both sides to a dispute. In any procedure that you shut out the other side, then the court will intervene to say, no, you have not given this person a fair hearing. So for example, in terminating people's appointment or taking disciplinary action, you must be able to show that the person you disciplined was given an opportunity to make his or her own response. Don't just say, kí ló tún fẹ́ sọ, what do you want to say again? Ọ̀rọ̀ òdùn lẹ́nu ìyá olè. Let ìyá olè say her own before you judge her. And you also say that the person who hears only one part and gives judgment is the master of wickedness. So the right to fair hearing. So much for the right to fair hearing. You have the right to private and family life. You are entitled to your privacy as a citizen in your home. Nobody can just barge into your home and then begin to without your consent. Right to freedom of thought, conscience, and religion. Right to freedom of thought, conscience, and religion. You are free to hold any opinion. If you like, you can say stone is God over everywhere, that you originated from stone. No problem. You can say you came right from inside the river. No problem. You are entitled to hold your own, so far as you do not lord it over any other person. You can stay away from any religious place or gathering. You can profess any belief you like. No person can be punished for entertaining or professing religious beliefs or disbeliefs. The question whether this is true in reality or not remains to be seen in the context of Nigeria. The Lord will help us in Jesus' name. You have the right to freedom of expression and the press. Freedom of expression and the press. Like I said before, this one, you also have cases where some people have been stoned just because they were understood to have said something inimical to somebody somewhere, and they gather together and stone them. Like I said, these are realities. These are realities in the case of Nigeria, in the context of Nigerian situation. Right to peaceful assembly and association. Peaceful assembly. The emphasis on peaceful assembly and association. Right to freedom of movement. Right to freedom of movement. Funny enough, some people are extending the right that is not yet granted to human beings. Some people are trying to extend it to movement of cows now. That there's right to movement, so Fulani herdsmen are free, they are entitled to freedom to move anywhere in this nation. God, we need your help in Nigeria. You have the right to freedom from discrimination. Cannot discriminate against you because of your race, your tribe, your place of origin, your political opinion, your sex, and so on and so forth. Everybody is entitled to equal treatment. Again, whether this is the reality in Nigeria or not remains to be seen. Right to acquire and own immovable property anywhere in Nigeria. I laugh. Up till now, up till tomorrow, there are places in this country you cannot buy property for a church. If you have paid, they will tell you, either if they are nice to you, they will return your money. And if not, if they are not charitable, they will tell you, as many times as you build that church there, we will demolish, we will burn it down. And they carry it out, nobody does anything about it. The right to acquire property is subject to compulsory acquisition of property. Government, for overriding public interest, sometimes acquire properties. Even though you have the right to own property, the government may acquire the property for overriding public interest. In such cases, compensation must be paid. And not just paid, it must be adequate compensation. With these few points of mine, I hope I've been able to convince you that Jesus Christ is Lord, that the law is good, depending on which side of the law where you stand. If you use the law lawfully, the law will be good to you. If you use the law wrongfully, just like an ass that it is, it will give you a kick that can even take your life. I pray that as ministers and workers, we will always be on the right side of the law. God bless you.